Welcome to this video series about the Iowa Guardianship and Conservatorship System for Adults. It was developed by the Institute for Guardianship and Conservatorship at the University of Iowa College of Law. This second video in the series will give you basic information about the court's monitoring of guardianships and the reporting requirements and powers of guardians. Please be aware that a guardianship must be created and conducted in accordance with Iowa law. The information in this video is for education only. It is not legal advice or a substitute for legal advice. You should consult an Iowa lawyer for legal advice if you have questions about a specific guardianship case. As Video 1 explained, a guardianship for an adult is a legal arrangement that the court establishes. The court appoints one person, called the guardian, to make personal care decisions for another person, called the protected person. Personal care decisions include living arrangements, health services, education, and other types of care and services. As Video 1 also explained, there are specific legal requirements establishing a guardianship for a person who is an adult. Based on clear and convincing evidence, the court must decide the person's ability to make decisions is so impaired that the person cannot care for or protect themselves, and the appointment of a guardian is in the person's best interest. The court's responsibility does not end with the appointment of a guardian. The court has a continuing legal responsibility to regularly monitor guardianships. Court monitoring is required to make sure guardians fulfill their responsibilities and protected persons receive needed care and protection from abuse and neglect. The court's main way of fulfilling its monitoring responsibility is through its review and approval of plans and reports that guardians submit. Iowa law requires guardians to prepare and file with the court an initial care plan when the guardian is appointed, an annual report of the past year's activities and a plan for the next year's activities, and a final report when the guardianship ends. Within 60 days of appointment, Iowa law requires the guardian to prepare and to file an initial care plan for the protected person with the court for its review and approval. This requirement has two purposes. One is to make sure the guardian identifies the protected person's needs and develops a plan to meet those needs. The other is to enable the court to identify and prevent possible problems in implementing the plan. Iowa law directs the guardian to consider both the protected person's preference, values, and prior directions, and the protected person's best interests in deciding the protected person's needs. The initial care plan must describe the protected person's current living arrangements and the plan for future living arrangements, and the plan for payment of the protected person's living expenses and other expenses. The plan also must describe, if applicable, the plan for meeting the protected person's physical and mental health care needs, other professional service needs, educational, training, and vocational needs, and social activity needs. In addition, the plan must explain what the guardian will do to encourage family members, friends, and others to communicate and visit with the protected person. This requirement is meant to prevent the isolation of and contribute to the well-being of the protected person. Most importantly, the plan must explain what the guardian will do to communicate and visit with the protected person. This requirement is meant to enable the guardian to obtain needed information about the protected person's needs and to develop a supportive relationship with the protected person. After approval of the initial care plan, Iowa law requires the guardian to prepare and file annual reports with the court for the court's review and approval. These annual reports tell the court how the protected person is, what the guardian has done for the protected person during the past annual reporting period, and what the guardian will do for the protected person during the next annual reporting period. This table shows what the annual report must describe. Guardians are not required to have a lawyer to help them prepare and file the initial care plan and the later annual reports. There are, in fact, many guardians who do not have a lawyer. However, it may be advisable for the guardian to have a lawyer if the protected person has complicated needs for which it is difficult to arrange care. The Iowa Supreme Court has forms for guardians to use in preparing and filing required reports. These forms are available on the internet. Guardians who do not have a lawyer must use the Supreme Court forms for reporting. Guardians who have a lawyer may use either the Supreme Court forms or some other forms. Whatever forms are used, the same information must be reported to the court whether or not the guardian has a lawyer. This table shows the links to the Supreme Court reports. Guardians should file required reports with the court electronically through the judicial branch's Electronic Document Management System, or EDMS. After appointment, guardians exercise various legal powers in fulfilling their responsibilities. Powers are the types of decisions the court authorizes the guardian to make on behalf of the protected person. The guardian has only the powers the court has approved. The court order appointing a guardian will describe the powers the guardian may exercise until the court approves the guardian's initial care plan. In the initial care plan and annual reports, the guardian should always request the court's approval for whatever powers the guardian believes will be necessary to implement the proposed plan for the next annual reporting period. General guardianship powers include making decisions for the care, health, education, welfare, and safety of the protected person. Since the needs of protected persons vary in different cases, the specific powers the court approves for a guardian in an individual case vary. Guardians are typically given the power to consent to and arrange for health care and services for the protected person. But a guardian must obtain specific prior court approval for withholding and withdrawing life-sustaining procedures from the protected person, performance of an abortion on the protected person, and sterilization of a protected person. Guardians are also typically given the power to decide the protected person's permanent home. But a guardian must get specific prior court approval to change a protected person's permanent home to a nursing facility, other secure facility, or secure part of a facility. Another power guardians may be given involves managing the communications and visits of the protected person with other persons. But if a guardian wishes to deny all interactions of the protected person with someone, the guardian must first get specific court approval to do so, and the court can give approval only the guardian shows good cause to do so. This concludes the video about court monitoring of guardianships and guardian reporting requirements and powers of guardians. We hope the video has been helpful to you. We encourage you to visit the website of the People's Law Library of Iowa for more detailed information and resources on this topic, as well as other topics about guardianship.